Okay, we're going to begin our second session of the day. For those of you who just arrived, I'm Paul Carisse. I'm the director of this new academic department at Arizona State University, the School of Civic and Economic Thought and Leadership. I encourage all of you to get a program for our two-day conference packed with information from the front cover that lists all of our co-sponsors and partners for this, to the back half of the program, which has information about the school as an academic department, our curriculum, and our faculty. We have a minor in civic and economic thought and leadership for undergraduate students. We expect next week to have our major approved. We have information on all of that out in the lobby area, including in the program and elsewhere available at the information table at the courses that we're teaching. If you'd like to know more information, we have a very full and busy and continually updated website, so you can get all kinds of information. And that reminds me to say that, as is listed on our front cover, we're very glad to have Arizona PBS and the Cronkite School of Journalism and Mass Communication as one of our partners for this year-long series. As you can see, Arizona PBS is recording all of this. So the video of the entire two-day conference session will be up on our website in fairly short order. All of the events in the year-long series on free speech and intellectual diversity are going up on the website. So 5 events are up already. And then Arizona PBS is producing their own edited versions of those events as a series they're calling Free Speech Challenge of Our Time. So spread the word and take a look yourselves at what we have there it's under the video section on our website. And with that, I will turn the panel over to our moderator, who is one of our partners on the planning committee for all of this year-long series of events and for this two-day conference. If you like how things are going, we would have to give credit to Jim Weinstein. If you don't like it, it's really mostly his fault. So bring it up with him. So I'll let Jim introduce himself, and then we're on to our panel. Thank you.
Thanks, Paul. I will do a very brief introduction of our distinguished panel, because we want to use the time for discussion, and they are described in full in your pamphlet. But we have, and very pleased to have, starting at the left, Donald Downs, who is an emeritus professor of political science at the University of Wisconsin-Madison. Then we have Azhar Majeed, who is vice president of policy reform at the Foundation of Individual Rights and Education, FIRE, which organization you've heard about. And then immediately to my left is Laura Beth Nielsen, is a research professor at the American Bar Foundation, professor of sociology at Northwestern. All 3 of these panelists are experts on the issue of campus speech and have written extensively on the subject. Now, for something completely different. Now, those of you who know the Monty Python, all 3 of the people my age who know the reference. Rather than what we've done so far of having each panelist discuss in turn, to give a presentation in turn, because of the sort of broad and somewhat abstract subject of campus speech in the First Amendment, we thought it might be better to facilitate that discussion by having several specific concrete scenarios that each of them will discuss. So, to begin with scenario number 1, the evangelical preacher. An itinerant preacher who is not a member of the university community comes to a traditional free speech forum like ASU, Katie Mall, or Sproul Plaza at Berkeley, and with a sign saying, "Homosexuality is sinful and sinners will burn in hell." So what I'd like the panel to address, would it violate the First Amendment if universities banned the preacher from delivering that message on campus? And start with Don.
Okay. Actually, I've had my own experience with the Westboro Church preacher at Madison, so this comes right out of my experience. They came to the public forum area before the student center, or the student union on Langdon Street. And I also was on Wisconsin Public Radio with the daughter of Phelps, who is the lawyer for the Westboro Church. What an experience that was. She spoke 90% of the time. And the way it works, 20 minutes interviewing the panelists, then 40 minutes of phone calls. And every phone call just said, how dare you give her a platform? So I didn't really have to do very much work. We also had a preacher from the same church, I think it was, who came to that same area, traditional public forum, and put up an awful picture of a fetus, an aborted fetus. And I was at a conference on the Moral Act in Mississippi, and I was getting all these student emails from my First Amendment class. Is this protected speech? And I said, look at the materials. And also, when it came to the speaker, to the preacher, some gay students and I actually planned a counter demonstration, a protest. And I said, they took my First Amendment class, so they knew you're not going to shout them down. This is a traditional public forum in terms of the law. You had a right to be there. University is not obligated to invite him, but this is a traditional public forum, or at the very least a designated public forum under the law. So we arranged a counter protest. Anyway, the panel is about the law. And I'm doing a book on all this stuff, like many other people here. And I want to deal with the larger issues. Why are we here? What's the purpose of the university? Things we've talked about in other panels. This is more about law, so it is a little more technical.
We'll get into
but
the other
hopefully we
thing.
can do the other stuff.
We'll get more.
So anyway, there are two realms here. Academic freedom realm, I'm with Post on that. It is the most important realm at the university with certain responsibilities. But you also have the free speech realm. And this goes back to Shermanensky and Post, where the normal rules of First Amendment public forum analysis apply. And I think that in this case, this is that kind of forum, which has to be viewpoint neutral. And then you look and see whether or not there are the exceptions to free speech in a traditional public forum or a designated public forum apply. And the answer is probably no. Is this a direct incitement to imminent lawless action, Brandenburg? Probably not. Is it fighting words, which have to be face-to-face, highly hostile expressions that cause a hostile reaction, and therefore a disturbance of the peace? And this is not face-to-face, this is public forum stuff. Is it a threat? Now, maybe if the preacher named names of students, like Milos does. I can never pronounce his last name, so we just call him by his first name.
Me neither.
And then names these students in a sinister way, then you're moving toward a threat. And we had a case in Madison, actually, where someone posted a very hostile comment on the dorm of a gay couple, and they were punished for making a threat. And we could argue whether or not it might be a little bit of a gray area there, depending on what they said, but I thought that was okay. You have the Westboro case, where they were allowed to put up signs during that military funeral, but they did it in a way which did not interfere with the funeral march. And I don't think the Westboro case would cover this either. So I think it really is protected. The real question then is, how do you deal with it strategically? Should the university comment? And we could probably talk about that a little bit later. The university needs to be careful when it says, we disagree with this kind of speech, because it opens up a kind of Pandora's box. But that is government speech. They have a right to do that. Inclusive speech model, that's what I did with my students. Provide a forum for the counter demonstrators to get their word out there. And finally, the protest idea, sort of an inclusive speech idea. So I would protect it. But I would also be careful to try to make it a constructive moment and take into consideration the concerns of the students.
Yeah, I mean, I think I would largely agree with that analysis. That I think that the forum analysis is such that you would have to recognize that it's protected. Having said that, what I would add here is that since this is a non-university affiliated individual that we're talking about, I think it would be reasonable for the university to place regulations on his or her activity in a way that would not be reasonable if you're talking about a student organization, or somebody else that's affiliated with the university. So if you want to require some form of prior notice about this person coming onto your campus, if you want to designate certain places on campus that are particularly well suited for this kind of activity, if you want to place other restrictions in terms of use of amplification or other aspects of the activity, I think that would be more reasonable than would be applicable to a student or a student organization. But otherwise, yeah, I think the forum analysis is such that if you're talking about a public campus, those rules should apply. Now, touching upon what Don said about counter speech, that's where I think a lot of this strategy of the university community comes into place. And as a free speech advocate, I often have to remind myself that it's not as easy or it's not as straightforward when you're talking about people that don't deal with this on a daily basis. And when you're talking about students, particularly freshmen, young students who are really experiencing this kind of thing for the first time. And so I think our role largely has to be as educators to explain why it is that counter speech and counter protest and airing of your own views is a preferable approach to calling for this person to be entirely removed from campus. So I think that's really where a lot of the strategic response properly lies.
Thanks, Azhar. Laura Beth.
Gosh, this is so interesting because I thought we were all going to say, of course it's protected, of course it's protected, of course it's protected, next question. But it's actually, I do think this is protected. So I come at this as a sociologist and a legal scholar. I study how ordinary people understand the law. And one of the things that I try to take seriously in my work is how people from all kinds of different backgrounds and so on interface with the law. And we're talking about, as Azhar said, oftentimes students 18 years old who haven't dealt with this kind of thing before. And so our role is to be the educators, both about what the First Amendment requires and how to be a participant in civil society. So partly, of course I would do nothing if I were a university administrator about somebody like this, but I would ask the question, are our campus police moving people who are asking for money? Are our campus police removing people with other kinds of messages? And as long as this is the free speech space on a public university, yeah, we can regulate it.
Okay, so let me ask this question then. Could a state university say, we don't want a designated public forum anymore, and we're just going to close it down? Now, we'll get later into that, whether that comports with academic values, but let's stick with the law. Could and let's do this quickly because then I'll come with something else. Would it comport with the First Amendment to say, no, we designated a public forum for all these years, we changed our mind, we've had it with this disruption of campus life? Could they constitutionally do that?
Yeah, I think technically they're allowed to do that with a designated forum, but the timing might matter. Is this in reaction to a speaker that we disagree with so much that it sort of raises the specter of a viewpoint discrimination? But then it would have to be applied even-handedly after that.
Okay.
But they're really two, like at Madison, where I was talking about, that's on a street right off of the technical
Right.
campus.
Right.
It's a student union, so it's
Right.
really a public forum in a traditional sense. They couldn't do that.
Right.
But if it were inside the campus, probably they could.
Right. I mentioned this
The
yesterday.
problem here, though, is a free speech zone problem.
Right. Well, we'll get
Where you
that too.
restrict.
I
Okay.
mentioned yesterday at ASU and a lot of large urban campuses, there really is no boundary. I mean, there might be a technical legal boundary, but just the streets just sort of bleed into the public street to bleed into the university. Are there any other comments, and we'll change it on whether it could be that the university could just change its mind and undesignate the forum in some viewpoint neutral way?
Yeah, the first thing that comes to mind for me is, is there an existence of a double standard? And I would say there probably or very likely is. And then the other issue that's already been touched upon is, if you're talking about sort of the quad in the middle of campus, that to me is different in nature from, the sidewalk that abuts upon the campus or a similar type of space where, what you have is a traditional public forum like a street or a sidewalk. So, that's where I would take it.
Well, and this is the problem with designated forum doctrine. Every forum is designated until it's not, or it's
Right.
not until it is.
Right.
So it's not very helpful.
All right, let me try and come up with a scenario. Might get a little disagreement, hopefully. If not, I'm sure I can find a way to get some disagreement going. So this university, this public university, has this new center for LGBTQ studies. A group of evangelical students really dislike this idea. So they go marching through campus with signs that say, out of Westboro, "God hates fags." They march through campus and end up with this, their protest in front of this new center and are waving these signs and perhaps even shouting these slogans for a while before they're going to move on. Could that speech is that any different? Does anyone think that's any different?
I mean, we're dealing with a continuum here, and it sort of pushes that arrow further down the continuum toward maybe being a threat, and then you make a judgment call. It depends on the language. Clearly, there's a difference between presenting a general message, and the Supreme Court has dealt with this when it comes to burning crosses. In a general kind of public forum, not targeted at any particular source. The targeting does sort of raise a specter of a threat, maybe a fighting word. I wrote a book on Skokie, that was one of my theories, but I applied it to the public forum, which I think was mistaken. But on the other hand, it's another First Amendment message. You have a right to take your message right to the source of the problem that you see. Martin Luther King went into Cicero, okay? You go right where the problem is, because that's where you're going to have the most discourse and the most tension that can lead perhaps to social progress. So here we're dealing with a more hateful kind of situation. If it's not a fighting word or a threat, and that's a judgment call here, I would still protect it. But I also have been be very careful and concerned about strategically dealing with that in a constructive way behind the scenes and interacting with the students involved.
I guess I'll provide some disagreement here because arguably to me, the fact that this message is being brought purposely front and center before the targeted individuals, I don't think that if you're talking about pure speech, that it moves it necessarily closer to a true threat or fighting words. However, I do think it enters the analysis if you're talking about the creation of a hostile environment. If you're talking about harassment on the basis of gender or sexual orientation or what have you. So I think that's certainly relevant to that analysis, where the tricky part of that for me is, if you're talking about people that are not affiliated with the
No,
institution.
I've changed it now. I'm sorry.
Okay.
These are students now. I picked up on these are now students at the university who are in front, who've marched through campus with this inflammatory language.
In that case, then it becomes a question of, does this meet the threshold for student-on-student or peer harassment? What I was going to say is if you're talking about somebody who's not, employed by the university or otherwise affiliated with them, then, it's hard to, obviously pin a Title IX or Title VII complaint there, although you could, I guess the hook would be that the administration in allowing this is culpable for the creation of a hostile environment. But yeah, certainly if you're talking about students, I think it moves it closer to peer-on-peer harassment. I would still say it falls short of that, but I suppose you could put together a fact pattern where this is repeated and it's really nasty things that are severe. It's objectively
No,
offensive.
let's leave it at one march through campus. Does that violate Title IX for the university
say
not
no.
to stop it?
No, I would say no.
Agreed.
I think it depends on, all of the facts of the situation. I think there's certainly, sexual orientation isn't covered by Title IX. It might be covered by your state or city ordinances. So I think once you begin targeting people, you're into a different ballgame if it's a threat. And the way that Virginia versus Black defines threat, it's really interesting that we haven't talked about that case until now, is hate speech, when done with the intent to intimidate, can be regulated. And when done with the intent to intimidate is an objective standard. It's a reasonable person standard, the same thing we use in law all the time. I will also add this is one of the very few times that Justice Thomas and Justice Scalia were on opposite sides of something where Thomas was saying, I know what a burning cross means every time. It doesn't have to be, it could just be presumed to be threatening. But the plurality of the court said it's the reasonable person test. So we have something that we use in law all the time to determine if it's threatening. If those students feel threatened, then that becomes a complaint that can be legitimately made and discussed. But I would argue the law is the least important thing here. This is the time for really good campus leadership, for town halls with clickers. There's a lot of technology out there for encouraging diversity of intellectual diversity that we haven't talked about. Have big classrooms, have people anonymously put their opinions up on these automatic screens, and then students know that other students in the room agree with them, and they're much more likely to make their arguments. I think that we have to make our arguments, well, now I'm into classroom techniques, and so we'll get there, but I think one of the things we haven't talked enough about is how in a classroom to embolden everyone to participate in a real debate or discussion.
What if it was
I'm sorry, we're not question and answer yet. So let's go to another scenario, one that is we've seen a lot of, but I want to get your reactions to. So we have a far-right student group at a public university who invites white nationalist Richard Spencer, to pick a name out of to campus. The group plans to pay for the event with funds allocated to it from student activity fees. Upon hearing of the invitation, the provost disinvites Spencer on the grounds that his views have no educational value and are antithetical to the community the university wishes to foster. Does this invitation violate the First Amendment? And also would like you all to talk about, even if it doesn't violate the First Amendment, but let's, does the disinvitation violate the proper role of American universities that would apply to private campuses as well? We'll start now with Laura Beth.
No, for the reasons that Professor Post talked about yesterday, I don't think a disinvitation violates the First Amendment. If the disinvitation is pretext for content discrimination, it's a more difficult case. But if this is about, as this scenario will go on, if it's about, spending millions of dollars, I don't think the First Amendment requires the university to become bankrupt. Let me just say that.
Well, we'll get to that, but how can this not be content discrimination? They're doing it because the provost says, because what this person is saying is antithetical to our...
Right, if there's no educational value, absolutely. I think that the university, the provost can, or the president or whatever, can certainly disinvite huge amounts of trouble for a conversation that they think is of no academic value.
Okay.
So if I understand the hypothetical correctly, the student group is inviting Richard Spencer or somebody similar, and they're paying for it through their own funds.
Well, the funds that are allocated...
Through
from-
students, through
Yeah,
student,
yeah.
but the funds that belong to the student organization.
Correct.
And then the university would step in and say, no, you cannot do this. We're going to prohibit you from doing that.
Correct.
I would say absolutely there's a First Amendment problem there. Now, I would change the hypothetical. If the hypothetical were changed such that you're talking about the university going through with inviting Richard Spencer and then rescinding that invitation, then we're in a different ballgame.
Well, leave it to the students,
Sure.
and they're overruling it. Does it violate the First Amendment?
I would say that it does, yes.
It does. And
Yeah, I agree, and I respectfully yet profoundly, in this case, disagree with Laura. That first, we have the Southworth case from my own university, and I was sort of involved in some of the background of that case. That once you set up a special forum for student groups to present their views and advocacies, it has to be based on viewpoint neutrality. If it's not, then you have the problem with compelled association, students having to give money that end up funding groups that they don't like. But the viewpoint neutrality of the forum, in a sense, mediates that and allows it. So this seems to me to be clear viewpoint discrimination. But and also, what type of forum are we talking about? It is kind of a public forum. The Southworth case deals with that. What are the motives behind this? Pretty much clearly viewpoint-based. And so I think there definitely is a kind of a problem there.
Laura Beth, would you like to respond to that?
Well, I think that we have to remember that a university is an educational environment, it's a workplace environment, it is where people live. There are both employees and employers, right? So we're talking about universities, and of course the mission is to educate, but there are a lot of spaces on university campuses for different kinds of events and messages, and we have to remember that this is also people's homes. And so if there is threatening behavior, and I mean, in some ways, Richard Spencer is the easy case now because of the history of, because of Charlottesville, right? And the cost to universities where he has spoken. Yeah, absolutely.
Let's
we're
leave the
gonna
co-
deal
I
with
want
the
to do
question of
costs
costs in a
on
minute,
costs
right?
in a minute.
Well, can I
But-
respond very quickly?
Sure, of course.
I mean, I think it's also, there's a kind of educational message being sent by a provost intervening with the delegated and autonomous decision of students to invite a speaker. And a lot of Supreme Court cases on student speech, going back to high schools and certainly into college, deal with the pedagogical value of giving the students this kind of authority. We've talked a lot here about, do we treat students as sort of minors or as children or as young adults that are capable of bearing the responsibilities of constitutional citizenship? And I consider this could be a challenge to that if we allow the disinvitation.
And one way to ask that would be, would you be willing to have him come in via Skype? Is this a provocateur? I mean, this is more of a Yiannopoulos kind of
Yeah.
example, but if it's really to engage with ideas, there are a lot of ways to do that aren't necessarily bringing that person onto campus if it feels threatening to.
Well, there are different ways of doing it, but just having his presence to challenge the free speech issues on campus is itself a pedagogical issue.
I mean, if the basis of the disinvitation or the ban is that his speech presents no educational value, I think that necessarily becomes a content and viewpoint-based restriction. Now, I would say that in in a lot of the commentary on these issues, there hasn't been enough of a distinction made between protests against speakers because of their views or perceived views versus protests against a speaker because he or she is deemed to not be a serious commentator or does not present, fact and evidence-based arguments or is otherwise not a respected expert in his or her chosen field.
Right.
So I think there is some distinction to be made there that may at some point enter the analysis. But if the basis is, this person presents no educational value, I don't see how you can make that judgment call without getting into content and viewpoint.
Well, it is content-based, but the question I
Or
would like to...
disciplinarily defined.
Yes, but that's content as well, and that comes back to Robert Post's point. The question is this what you're all are referring to as the classic First Amendment and the rules for public discourse outside the university? Robert Post, and I think quite persuasively said, well, it's a mistake to measure it by that, and why can't you measure it by educational value? You raise good policy concerns. You might want to have to make an educational moment out of it, but may I suggest, and I may give my own views, if we keep the First Amendment out of it, the classic First Amendment out of it, that would create a lot of diversity for different campuses to do different things. Right. And that would be, if I can put my 2 cents in. But now let's go to what we've been touching on a little bit, the cost. What if, instead of directly overruling the student group, the university says, look, we want you to pay for this, and we're paying, hundreds of thousands of dollars, and so they effectively shut it down because the student groups don't have the money to pay for this. How does that work?
Yeah, that's a difficult kind of case, and I mean, the law there is sort of based on a supposition or presupposition that this really controversial people and the provocative people aren't going to take advantage of their free speech rights all that much. Think of the New York Times versus U.S. in the Pentagon Papers case and prior restraint. What if the press kept publishing articles about the next day's military incursion overseas? Eventually, the doctrine of prior restraint might have to change because of necessity. But we keep it in place because it doesn't happen all that often. Nazis go to Skokie. That would have cost millions of dollars had they come. Now, just talk to me after this. I studied the counter-demonstration plans and all that. 40 police departments around Skokie on Sunday double pay to take care of that case had the Nazis come. And the courts nonetheless said, you have to let them come. But the courts did allow a prior restraint to exist for several months so Skokie could get ready. But at the end, it would have been really costly. So you have that. Then you have the Forsyth County case, that the fees cannot be unreasonable to an extent that it'll shut down a group from coming. So that law is sort of in place there, but it's what happens when groups take advantage of that in order to sort of test universities or to break universities. Berkeley, $1 million, right? They spent on those 2 speakers. That's not going to really be sustainable. So where do we go from there if indeed this continues to be a problem? Maybe we can just hope that it stops being a problem so we can maintain our present doctrine.
You know, I think the best thing that universities can do in these kind of situations is be prepared and have policy in place so that they can make these determinations on clear, consistent, and objective criteria. What I would always say is have a policy that looks into factors like the anticipated size of the audience. Is it something that's only open to the university community, or is it something that's open to the general public? Is there going to be, what is the nature of the forum? Is it an indoor facility versus outdoor? All those things that can come into play in making a reasonable assessment of the necessary security costs. Now, having said that, in this hypothetical, there's obviously some tension here because, on the one hand, as Laura said, do universities have some obligation to make themselves go bankrupt so that these speakers can come onto campus? On the other hand, the tension lies with the idea that public institutions, including public universities, are supposed to be, the ultimate bastions that protect our rights. In the same way that the state has an obligation to address things like riots or public disorder or even a championship parade. Those things the money for all that has to come from someplace. So maybe the idea here is to conceive of this as coming from that kind of a general state fund and not something that's necessarily university specific, such that the school itself is, quote unquote, going bankrupt in order to host these speakers on campus.
Laura Beth?
Right. I totally agree that another kind of source of funding for this would solve a lot of problems. This did just happen to Richard Spencer. He was invited to speak in a government building, right? So the government owns it, and it's managed by a private management agency that required a prohibitively expensive insurance policy for the event. And that you really do run into complicated questions about money and insurance, but I don't think we want insurance adjusters making our decisions about the First Amendment. So I think we want to try to control it, and I'm glad you mentioned the parade, because what that's doing is bringing community together to be excited and happy about something. It's expensive and there's problems, but what this does is builds resentment towards the university, right? It's going to be this whole big nightmare, and people are going to set garbage cans on fire. And then, as we heard yesterday, what's the easiest thing when your state's under crisis? What's one of the first things they want to cut? Money for public universities. And why? Because of these events. So we have this circularity where, by being a bastion of protecting these rights, we're further diminishing our ability to do that financially.
Well, take it from me as somebody whose organization is based in Philadelphia. A championship parade may bring people together, but cause the same kind of destruction.
Don't rub it in. That's not fair.
As something that's like bring Richard Spencer.
I watched the videos of the Four Seasons.
Let's, we've been talking about student speech, and I think very productively. I think it shows these aren't easy questions. These are complicated, and it requires thought and discussion like this to come up with the right answer. Let's now move to professorial speech. Let's start in the classroom. So we have a Professor Merstein, who teaches a graduate seminar on the measurement of human intelligence at a state university. In this seminar, Merstein states that he believes that genetics, as well as environment, play a role in the disparity in IQ test scores between whites and blacks. Now, students, other faculty, and members of the community are outraged at this suggestion by Merstein, and they demand that he be fired for saying this. Would firing him for making the statement about genetics and race, would that violate the First Amendment? And because I want to also bring in private schools here as well, even if it wouldn't violate the First Amendment at a place like Harvard, the ASU of the East, would it violate academic freedom? So why don't you address both of those, the First Amendment and, you want to go, well, let's Azhar go first.
Yeah, you go first.
Well, I would say, the touchstone inquiry for me is germaneness. Is this something that's relevant to the classroom? There has to be broad protection for a faculty member to to run his or her classroom discussion and the course material as he or she sees fit within subject matters of their expertise. So the mere fact that something is controversial or offensive or divisive, even within that classroom, if it's germane to the course discussion, then certainly there's an academic freedom problem with disciplining or ultimately removing him or her from teaching on the basis of those comments. To the private school question.
How about the First Amendment in the public? Does it violate the First Amendment to fire
I would
him?
say that it does. I would say there's a larger academic freedom issue there because you're talking about the classroom and you're talking about the ability to operate that within your expertise and within your chosen profession. But I would also say there's a First Amendment violation there. Now, with private schools. What I would look to is what the policies of that school, what the faculty handbook, what those kind of materials say about these things. So if you have, as you said, Harvard, the ASU of the East, I'm sure if you look through Harvard's materials, they broadly proclaim that this is an institution committed to free speech and open inquiry. Professors' academic freedom is fully protected here, no matter what, no matter how controversial their views may prove to be. So if on the one hand you have that in your handbook or in your policies, but on the other hand, when the rubber meets the road, what you're going to do is remove this professor from teaching or fire him or her on the basis of those comments, then I think you arguably have a violation of the terms of your own policies, and that's an area where we could get into whether the courts would really side with the individual faculty member and whether the law is as clear as it is with respect to the First Amendment in a public institution, but certainly there's a policy inconsistency issue there.
Laura Beth, what
It's
is?
surely a violation of academic freedom to fire this person. I don't think that, especially in a graduate seminar, where students are expected to be able to take on old arguments, right? I mean, this happens in every discipline, maybe not as controversial as this, but you have people with tenure that are teaching 40-year-old stuff from their discipline. And part of teaching graduate students is how to sift through and analyze the data. Now, there are new, if you think about Jim Heckman and his stuff about early childhood development and the relationship between genetics and environment, there's new stuff too. So it depends on, right? It's not appropriate in a calculus class. It's probably not appropriate in an undergraduate class where the undergrads don't have the intellectual capacity to contextualize it. But in a graduate school, certainly firing him is out of the question
get to other sanctions,
if he's
I
been
think.
granted tenure. And we haven't talked about the increase in universities staffing untenured people precisely to make these kinds of issues easier for them to fire.
Let me ask you a question
faculty.
about that. Why, let's say he was untenured and was fired for saying that in a graduate seminar. Would that make a difference?
Do you mean not granted tenure?
No, I mean he makes a statement about race and genetics. He's pre-tenure. He's coming, and they just fire him.
It would certainly violate the tenets of academic freedom at all of the universities I think that we come from.
And also the First Amendment?
I think it would be an arguable case. I mean, I don't know, right? The only people that matter are the Supreme Court justices in that question.
Don?
The problem is the First Amendment status of academic freedom is so undetermined. And it depends on the circuit. On the Second Circuit, they actually look at whether or not there was viewpoint, you're being fired or disciplined because of your viewpoint. But they can find 10 other reasons, perhaps.
No,
Pedagogical
if anything
purpose,
is viewpoint
that kind of
discrimination.
thing.
I mean, and viewpoint discrimination
Viewpoint's
is,
different from content,
yes,
right?
but this isn't, if anything is viewpoint discrimination, if he had said that there is no genetic.
Right, he's fine then.
His all sociology, he wouldn't have been in all environment.
Exactly.
No, this is, doctrinally, I'll tell you, if anything is viewpoint discrimination,
right.
this is it. So,
Yeah. Well, in terms of the private school thing, as I mentioned yesterday in response to
can I get an answer on the public school? Does it violate the First Amendment?
Yeah, well, it depends on the circuit, I suppose. But yeah, I would say yes, because it's just clearly viewpoint neutral if you're going to protect academic freedom at all.
Okay.
But here's a lawyer that responded to David Demers, who's the guy that won the first circuit court opinion sort of again, working against the Garcetti case, which we can talk about in the Q&A. He said, listen, no one wins academic freedom cases. The only cases that win are those arising from the so-called protected categories. If you're a woman, a minority, over 50, or have a unique set of religious beliefs, you might have a chance, but none of that apply to you. And the universities always find different things. Academic freedom status is really kind of undetermined under the First Amendment.
It is.
Again, it depends on the court and the district. But in terms of pedagogy, I think, Azhar pointed out the importance of germaneness and relevance. It's clearly, this is a germane, relevant consideration here. Is it held on the basis of academic and intellectual competence? Well, we assume so. We don't know all the details of the case. Intellectual honesty. Yaroslav Pelikan, who wrote a book about the idea of the university re-examination, lists intellectual honesty as one of the 3 major criterias or values of the university. And that means if you say something that you really don't believe because you're concerned about pressure, aren't you kind of engaging in a kind of intellectual fraud? Maybe not technically, but I think normatively. So is he speaking honestly? I assume so. There's also concerns about indoctrination. AEUP has a whole section on what is indoctrination in teaching versus non-indoctrination. And basically indoctrination is taking a dogmatic, intolerant view on an issue that is subject to contestation. Is that going on here? Okay, there's something else
No,
to consider.
it's not. He
Yeah.
just, he makes,
Yeah.
says,
So I
he
think-
says
I
that's
think
his
he's going-
belief.
Does he
And
give
also-
people Fs who don't agree with him?
No.
And the
And
same-
he encourages full and
Yes.
free exchange of
Yes,
ideas.
as much
Good
as
for
any other
him.
professor.
And to
though,
think
yeah.
about the sanction here, we're talking about the death penalty for one comment that was intellectually and competently held. And it really disturbs me. You read Jen, I forget her name, the one who wrote the book about the I generation. And what, over 20% of students in the I generation think that a professor should be fired for one unintentional, insensitive remark.
Hasn't that happened? Hasn't fire had
Yeah.
cases where professors have been fired?
Yeah, I mean, if you say the wrong place at the wrong time in front of the wrong audience, and all of a sudden, as Laura Kipnis will tell you, or Alice Drager, all of a sudden you're kind of fighting for your academic life. So, I don't want to overstate the problem because you're talking about some cases and not this happening at every school with every faculty member, certainly anything like that. But yeah, there's enough of a pattern of that happening that it's troubling.
Can I make one
Laura
quick more
Kipnis is
comment
still
about the law?
gainfully
Or-
employed at my university.
I mean, the tenure thing also gives you a liberty or gives you an interest vested in the position. Tenure does that. So that goes through sort of the procedural due process
Yes,
stuff in
yes.
constitutional law,
Yes.
which I once tried to teach, and I couldn't make much sense of it, I'll be honest. That's different from academic freedom per se.
That's right.
Without tenure, you don't even have that going for you.
Let me come up with a different sanction or response, and something that you've mentioned that maybe I think is more common. That it actually happens. Let's say that Merstein, besides teaching this graduate seminar, regularly teaches Intro to Psych course, which is mandatory for all psych majors. And the students, minority students and others say, we won't be treated fairly, This guy has just said that, that he thinks we're genetically inferior and we don't want to take his class. So the chairman of the department says, all right, Merstein, you no longer teach this large intro to psych. So now I'll really go into hypothetical fantasy. Let's say Merstein really likes teaching these large introductory courses.
Who is this Merstein
Now
who wants to teach this
I know
class?
I'm really pushing it on beyond belief now that there's a senior professor who really likes teaching these big intro courses, but he does, and they say no, you can't do it. Is there a problem either with First Amendment or academic freedom now with that response?
Absolutely, the department has the not only option, but the responsibility to introduce people in the introduction to psychology, 18-year-olds who have probably never had a psychology course, maybe some have had AP Psych, to an accurate representation of the best science in the field. And if that means telling Merstein he cannot teach that course because he cannot teach the core of the
Oh, I'm
scientific
sorry, what if he doesn't,
curriculum.
he's not gonna mention it here, because that intro psych doesn't cover this stuff. He's not gonna mention it, but they know, everyone on campus knows what he said in his graduate seminar. I'm sorry, he's
Oh,
not gonna.
sorry.
Yeah, no, it's my fault. He's not going to mention it. He never has in this large class, because it's not going to your point about relevant to the subject matter. They're just telling about rats and Skinner and stuff like that, and they're not going to get to that. But the students are afraid that he's not going to be treated fairly.
Right, this would be the kind of issue that with good leadership, it would not come up, because the psychology department would find a way for this person to feel fulfilled. He could teach a seminar about that, and people who opted into a discussion of that could opt into a discussion of that. And if he's really as free and open to critique and to new science, then, and I think it's really important, as I said yesterday in a comment, these kinds of issues raise one of the most important things of teaching students the difference between a normative and an empirical claim. People use empirical data to make their normative claims, and we have to help our students learn how to sift through and know the difference, and how do you interrogate the science? We might say, okay, let them teach it, and then let's have another seminar where we interrogate the science of it. And this is what we're doing through the peer-reviewed scientific process. It gets to Eugene, wherever you are. Hi, Eugene. This question about, can we trust them? We have to trust the scientific process. We take the drugs when we're sick because we believe in the scientific method. Our kids are sorely lacking in the basis of the scientific method, and we've got to teach it and teach them how to disentangle the empirics from the normative.
And so if his science is bad, as it probably is, it would come out in the
Right,
in
and
the
he
wash.
could be denied tenure.
And so we have about 2 more minutes before we're going to Q&A, so Don and then Azhar.
Yeah, I mean, academic freedom is a complicated thing for a lot of reasons, institutional versus individual, et cetera. And departments have an academic freedom kind of right to determine who's going to teach what courses. And of course, in the real world, we try to work that out collegially, so there's not going to be any conflict, but sometimes conflict arises. There's a guy who wants to teach creation science in an intro biology class. There was a real case that went down. He lost in summary judgment down in Louisiana because they said, no, you can mention it in the class, but you can't make it a whole formal thing.
No, to be clear, he's the concern with the students is that they don't want to take
Right.
it's a mandatory class, and they don't want to take it with this racist.
But that raises a different kind of question, all right? Then you kind of get a kind of a heckler's veto,
Okay.
maybe misapplied to this context, but it's sort of different from the creation science example. And it could be, again, I think Laura's right, that we need to try to deal with this thing in a pedagogically sensitive and strategic way to prime the students to be able to handle that. But to say, we're not going to have this person teach it because some students are really upset about that, that may send the wrong kind of message. It may be too condescending to the students' views, depending on the situation. We should be concerned about that. But I don't think.
But that's a policy. That's not either a First Amendment or
That's a
academic. That's
policy
just good
question.
policy, which is something we
I
could
think
talk
in the
about.
end, the department probably wins.
And Azhar, the last word, and then we'll go to
I would be troubled if the real basis for that academic decision was the real or perceived opposition on the part of students. I think there's an issue there. Now, again, as Don said, there's the institutional and departmental academic freedom to determine who's best suited to teach what course and so on and so forth. So there's certainly a balance there. I think it's difficult to make that determination purely in this hypothetical situation, but you certainly have to have some deference to the school and to the dean and to the department in terms of how they decide who's best in that position.
Okay. Shall we turn now to the audience for
While you guys queue up.
Q&A?
I would
You
have
need to go to the
stereotypes.
microphone and give your
Stereotypes,
name
right,
and
if they made
school
that
or other affiliation, and please keep your, unless, I think there's going to be a lot of people here, so please keep your questions to a single question and keep it short.
I'm actually going to
Please.
start. It might be a little bit controversial what I'm going to say, so I'm going to identify myself as Jim Stoner, Louisiana State University. So many of these issues are judgment calls, as even the lawyers here would say, and majority and dissenting opinions in courts would say. So I want to get to the background issue about the culture of higher education that Robert Post raised from the beginning. Does it make it more likely that Richard Spencer or his ilk will be invited to more campuses if leading campuses won't tolerate having someone like Charles Murray speak? If there's such evident, reasonably discerned ideological, philosophical narrowness on leading campuses, does it provoke the polarization of toward lesser kinds of discourse that a Richard Spencer might indicate?
Please.
Great question, and I
Really
think
good.
it does. And it actually adds to the pedagogical justification for bringing a person like that to sort of test the university. And I don't like that. I try to talk conservative groups into bringing in really substantive people, partly because it gives conservatives a bad name to bring in someone like him, but also because of my concern about the intellectual mission of the university. But if students have a right to bring him in, and they do, and then the university goes crazy, that creates a question about that institution's commitment to that dimension of the university, which calls out for a response. So I think the answer is yes to that.
You know, you also have to keep in mind that irrespective of what the university's policy, irrespective of what students or student groups want to do, you know, sometimes these individuals come to campus uninvited. You know, they want to rent the facility because the university has a longstanding policy of making certain facilities available for non-affiliated individuals to come and have their lectures or rallies or what have you. So, you know, that problem's not going away, you know, with what the university or what the campus community decides to do. So, you know, you certainly have to keep that in mind. And again, I'll go back to what I said earlier, that if you have a sound policy in place that allows you to have clear, consistent, objective, content or viewpoint neutral criteria for, allocating those facilities and, you know, really the procedure for going about that, then you're in a much better place than if a school is just kind of in a reactive position, they're backpedaling, they're essentially making up policy as they go along. That's where you find yourself into trouble. So you certainly have to anticipate that problem before it comes to your campus.
I think this is a good moment to ask students, why do you feel that you need to have Richard Spencer, and what are we not providing intellectually? And that's, we were talking about this at Colby College, where I was a few months ago, having similar debate about having really good faculty governance with all kinds of student organizations, right? And so if you feel there's something pedagogically missing at the university, let's try to fill that hole rather than creating a flashpoint that's going to cost everyone money and make everyone angry about it. Let's try to fill the hole. What is it exactly? And let me help you understand why it's not Richard Spencer. Maybe you want, you know, I don't know, Clarence Thomas or something, but let's push it towards something that furthers the academic mission, and that's how we teach.
Eugene.
I totally appreciate the concern about having to spend all of this money that could have been spent on other things like faculty research supplements.
Your
for
virtual
security.
reality.
Right, exactly. But here's the thing that concerns me. And let me ask you this, hypothetical. Imagine that some Jewish students get very, very upset at what they perceive as all this anti-Israel, all these anti-Israel events. And they figure, you know, one thing that seems to have worked in suppressing other kinds of things is just send in enough death threats. It's actually kind of cheap. You don't even have to necessarily show up. You just send in some threats. And then the university says, oh, it'll be so expensive to set up this the security that they just cancel the events. Let's see if that works. And by the way, this is not exactly a hypothetical. There's a case, Seattle Mideast Awareness Campaign versus King County from the Ninth Circuit, which actually involved the King County Seattle transportation system basically starting to refuse all ads related to the Israeli-Palestinian conflict because of threats that they'd gotten from people who were upset at anti-Israel ads. I certainly I don't think that all or most Jews would take this view. I certainly wouldn't. That is to say, of sending in the threats, but a few people did, and that was enough. And I wonder if people are learning this lesson, if we're going to see more of that. So my question is, let's say that somebody tries to get kind of anti-Israel events canceled that way? Would you say, look, sorry, we'd normally be open to anti-Israel events, but it's going to cost us too much to secure it? Or would we say, well, this kind of speech we're willing to secure, even if it's really kind of radical anti-Israel speech, even if it's not very intellectual, but that's a legitimate viewpoint that we are willing to spend all this money to secure, but this other kind of speech we're not?
Well, it's not hypothetical to me. I've been disinvited from campuses. I'm probably not on the fire list. Perhaps I should be added. But yeah, it ratcheted up. There were death threats. I also get lots of rape threats. People like to threaten to rape me, and death threats. And it became, you're going to have 2 personal bodyguards. The Westboro Baptists were involved, but I do think the person who argued the most recent major Supreme Court First Amendment decision does further the academic conversation. So is that argument abhorrent to me? Absolutely. Do I think it's important to bring her and me in a conversation together? Yeah, and it got canceled because of threats. The other big question was I even going to go? Let's say they decided to do it. Am I going to go? Am I going to wear a bulletproof vest? This is just, it's ridiculous. And part of why I wanted to go was to point out to people that after she won the case, that then our Congress passed the Honoring America's Veterans Act, which recertified the idea that you can't actually protest around veterans' funerals. 500 yards, 48, or I can't remember the hours before and after. But I think it's an important lesson about how when the First Amendment is brought to speak truth to power, we often see a congressional response, right? We need to see this in its whole.
To Eugene's hypothetical, not only to me is there legally speaking, a heckler's veto problem there, but I also think just as a matter of policy, what you would do is incentivize some type of intolerance against speech, and that's only going to lead to more individuals doing the same kind of thing because they see that it gets results, or the results that they want. So I just think that's the dangerous precedent that you set for your campus.
Yeah.
Right.
Yeah, and
Yeah.
Brett Weinstein's, maybe the internet's the enemy of all of us when it comes to this stuff. You got to distinguish, real from unreal, reasonable, unreasonable threats. And yet, what do you do here? Is it a matter of quantity? At some point, you think if there's 1 or 2 threats that come through, and then something really bad happens because you didn't have enough security, then bam, the lawsuits. Oh, look here it was. It's like the FBI ignoring those reports about the guy in Florida.
Well, and it was one of those.
It's a real dilemma.
And it's one of those things that if you actually want to have this debate without anybody being able to kill each other, have it virtual reality, right? If we really think this is a way to do it, bring it on. Let's be on big screens. And you don't know where I am.
But we all live in a world of threats. I have had threats too.
We all do.
And I was disinvited back in 1995. You should put me on fire's list, but you want to go back to 2000. Right. So that's a thing we have to try to navigate now. But you can't surrender the ship over this. But you also cannot be unaware of the problem that Eugene raises.
Thanks. Yes, please.
So we've heard examples and hypotheticals of how the First Amendment
Give your
applies.
name and affiliation. Your name and affiliation.
Sure, Sterling Kellis, University of Phoenix. So we've heard examples and hypotheticals of how the First Amendment applies to a citizen walking onto a campus or into the public space, or as far as just students walking and protesting, as well as academia or the faculty. I'm curious to hear the panel's thoughts on how it applies to administrators or an official of the state. To hear the thoughts on how the free speech applies to administrators and officials of the state. So just one quick, hypothetical example. Thomas Jefferson, as headmaster of DC Public Schools, purchased controversial text, Bibles and hymnals for the DC Public Schools. Would that be allowed in 2018 today? Or for example, let's say a dean of a law school wanted to put a piece of art in the public square in the atrium, and it was, let's say, the lawgiver Moses with the 10 Commandments. So would that type of speech be allowed from an official of the state or an administrator? And I'd like to hear your thoughts on that.
Well, I certainly think that if you're talking about officials that work at a public university, they should have First Amendment rights. The problem is the Garcetti decision. and the sort of the cloud that leaves over that whole issue, at least with respect to faculty. The Supreme Court in that case reserved for another day the question of whether that holding applies to faculty speech in terms of their academic duties and their research. With public employee speech doctrine, I mean, you're in a tough position there. I do think that public university administrators have a role to play in terms of campus discourse, because not only within the community but to the world at large, because they have a unique perspective and they have their own expertise to offer that I think the public and the campus can benefit from hearing. So to completely shut them down to say well, you're just here to steward this program or to play this role in terms of running this office on campus, I think is a mistake and cuts out valuable contributions to the greater discourse.
I think there's an important distinction to be made between faculty members and administrators. Sorry, Stefan. No, and there was a couple of cases about this in the 90s, I believe, department chairmen. There was one department chairman, I think both New York universities, one sort of a black man who was making anti-racist statements about white people, and a white guy was making racist statements. You might want to protect the faculty member if it's germane to the subject, but I think you can pretty much just get rid of, the president of the university can just get rid of someone without any First Amendment or academic freedom thing if he's or she's just it's made the job as administrator impossible. If the president of the university, if the Board of Regents had a very strong affirmative action program and the president of the university says, I don't like affirmative action, I think they could fire him. Of course you have a right as a faculty member to oppose affirmative action. But I think administrators are in a very special position in terms of academic freedom and not having the same kind of interest in academic freedom and First Amendment rights as faculty members, so I think that. But
then you have the Goldwater proposition that universities should remain neutral when it comes to public policy issues, or the Goldwater blueprint for higher education. You should distinguish something, a policy that's relevant to the university, directly relevant.
I think that's probably right.
But when you speak, you need to, as the institution, you need to be careful not to do it in a way that signals to those who disagree that they shouldn't speak out.
But if administrators say something that makes their job untenable to do their job as a president or a chair, I think it's a very different thing than a faculty member. Anyhow, let's move on with the other Weinstein.
Brett Weinstein, professor at large. So I'm not sure exactly how to do this, but I have the sense that you all have surfaced the elephant in the room. And yeah, is right. So I'm going to speak very carefully. I would like people not to read anything into what I say beyond what I actually say. May I ask how many hard scientists there are in the room?
What does hard mean?
Oh, the biological sciences, physical sciences, chemical sciences.
Natural science.
I'm it?
No, there's one back here.
Okay. Computer science. Good enough, I think, actually. All right. So I am not a legal scholar. I sat and I listened to your discussion, and it seemed that in your, was it Merstein example, that much was predicated on the idea that what Merstein was saying in his class was transparently false. Is that correct? Is it contingent at all?
We didn't address that.
I think, well, the way I took the hypothetical when it was proposed was that. But as I mentioned, I think that and I don't know, because I'm not this kind of scientist. Well, neither is Heckman, right? I mean, he's an economist. But I think there is new science about, I mean, you could probably explain it better, but about early childhood development's effects on literally DNA.
So let me just say, in order to keep myself out of trouble, the bodies are buried under the word heritable, right? If you were to look into the word heritable, you would discover it is a logical mess, and that is going to get us into tremendous trouble. It's not important that we sort that out in order to understand what you've surfaced, but the question is, should the viability of a professor's assertions in a class be contingent on the fact that they are consistent with the conventional wisdom in that person's discipline. Because if the answer is yes, then we have a huge problem, which is that all of the great ideas start with a minority of one. And the last thing you want to do is build a system in which that minority of one is shut down by virtue of the fact that they are out of step. So it seems to me that we have to protect those out-of-step views, even though 99% of them may be junk. And in this particular case, I have the sense that people who are not in the hard sciences believe there is a consensus within the hard sciences that is not actually a consensus.
I don't think that was stated, but you raise a very good issue. Wouldn't part of the decision what to do with Murstein depend on what facts he could adduce
Right,
for
when was
this?
his last peer-reviewed journal article? Is there a peer-reviewed journal article
What's
on
he
this?
relying on for this? Is it different than Holocaust denial, which you could fire a historian for Holocaust denial, because that's just incompetent? Is this different, or is there something, and this is you raised the question, the hypothetical did not contain the answer. But I think that's got to be part of the analysis, right?
It has to be part of the analysis, and I'm afraid the news is really, really bad with respect to science, because science is constantly reversing itself, which people might take as an indicator that it isn't very good, but actually it's an indicator that it works.
Yeah.
So you can't halt that process by declaring current knowledge the end-all and be-all, because that's not what the history of science tells us is true. So anyway, this particular case is unsettled. There's a lot we could say about it, but I think it's unnecessary. Somehow we have to have, if the university system is about inquiry, we have to have the ability to tread into dangerous waters. And this one in particular, as I said when I was on the panel, if Charles Murray is right, we have a very serious problem in civilization that requires us to discuss it. If we can't discuss it because we're going to pretend that it's so settled that no discussion is reasonable, then now we have a second problem.
That's a great unsettled question in academia, because we have to rely to some extent upon the major consensus within a field, but we should never take it as sacrosanct. The John Stuart Mill principle, the fallibility principle. But then you got to be able to distinguish that from the quack that comes in. And hopefully we don't make errors, and you should err on the side of freedom when it comes to this as a matter of policy. You're absolutely right, and I think it's a tremendously important question.
Right, and law has a way of dealing with this, because law likes certainty. We have this Daubert standard, right? I mean, law has wrestled with this question: how can we know when we have to make a decision? How do we know when we know something as a scientific community? And the standard shouldn't be the same in the courtroom as it is in the research of a scholar. I totally agree.
One more very short question. Several very short questions.
First introduction, my name's Corbin Witt, ASU student. And in your hypothetical of the Professor Murstein, it seems that there's not an explicit policy recommendation or political ideology being pushed by Murstein. It's, whatever he has may be backed up by his research, may be false, but there's not an explicit recommendation that he's making to his students. He just believes those things. However, another hypothetical could be made for people outside of the sciences, maybe in the humanities, where students are listening to the professor make explicit policy and political recommendations, as has happened to me in the past, and it causes what may be a threatening environment where students do not feel able to speak up because their professor has said, well, this politician is the only one that I want to see, or this policy is the only one that I want to see ever passed, and if you speak out against either of these, you are a Nazi, you are a white supremacist, regardless of whether or not, if in my case, you're not even white.
Well, that raises
That's a really bad professor.
ideological professors using a podium for their ideological views, particularly if they're intolerant of contrary views, is a huge question. I don't know that we have. Does anyone want to say something very quickly about that?
Well, I think
it's inappropriate. Let me say that.
Well, I think Laura touched on it earlier. Does the professor create a classroom environment that makes it clear that views to the contrary are not welcome. Are students given an opportunity to disagree, or is it made clear to them that, if you do so on a particular assignment, your grade will suffer for it? And does the professor, does the professor's speech or conduct call into question his or her fairness in terms of treating students and grading their academic work? I think those are the questions there, and I think that kind of goes along with what you were just saying.
I agree. I mean, there's different ways of having good pedagogy. We've all had teachers that had different styles and different approaches. Some of the best professors I ever had that actually encouraged me and got me going into academics taught with a point of view.
And I think
But
students,
they did it in the way that Azhar was talking about.
students should demand to know, especially in areas like law, politics, social sciences, humanities. I tell my students, here are my political leanings. You should demand this of all of your professors. Maybe not calculus, but maybe. I don't know all the fights about calculus. Here's what I'm committed to. And then I model making the best possible arguments against myself. If I can't get the students, if I can't elicit it from the students, I make it. And I strongly encourage those. And sometimes I'd say, here's how to make your argument a little bit better. Do you want to have that argument in front of class? That's good teaching, and that's our responsibility.
My name is Nidal Selmi, ASU student, and my question is, with the growing number of international students attending American universities, myself included, do you think the American university can serve as a role model that promotes First Amendment values and intellectual diversity to the world, or at least should the global influence of American universities be considered when crafting policies that affect freedom of speech and academic freedom? Because I think that the world is also watching what's happening at the American university, and they're trying to kind of learn from that experience.
Anyone? Don?
Yeah, I mean, I'm all for us sort of leading the way there. I thought about writing a book about First Amendment and in relationship to American foreign policy, and I didn't get anywhere with it. But yeah,
were
we need to
censored
be true
in
to
your book.
ourselves. We need to be what we are, and then let that example flow. If we're not true to ourselves and we have doubts about our intellectual integrity and our intellectual mission, then we're doing not only ourselves a disfavor, but I think the world a disfavor.
I mean, I think there's room for American universities to learn from their international counterparts and vice versa. What this does remind me of is the debate about hate speech on campus, and oftentimes proponents of hate speech regulation will point out that, if you look at Europe, if you look at a lot of other developed nations, they have much more stringent regulations on quote-unquote hate speech than does the American legal system. And so perhaps, we would be wise to follow suit and to sort of import that here. So, of course, as a free speech advocate, I'm going to say that's not something that we should do because it's incompatible with First Amendment jurisprudence, but also incompatible with free speech principles at large. So that's one area in which I hope we don't see importation of those values.
That's the topic. This is the topic of, well, not exactly, but sort of the topic of my first book is attitudes about free speech. And actually, most ordinary citizens don't think we should have hate speech regulations. The reasons differ. They're not all about the First Amendment. In fact, we're a very weird group to be thinking about what does it mean to hurl epithets at each other in terms of the law. That's not how, shockingly, ordinary people see it. So I think there's definitely a lot to learn from other places, and I'm not sure about the American exceptionalism. We're the city on the hill. That makes me nervous.
Steph.
This is the last question. And yes, I can be fired or I can be removed as an administrator. Thank God I have tenure to fall back on, Jim, just in response to your point. I just have two quick questions. One is, can a university create a de facto public forum? So for example, let's say you've got a poster board, okay? And students just put up their events, et cetera, up there at will. And then someone puts up a poster that's objectionable to the university administration. Can the university administration take that down if they have otherwise allowed other posters to be put up at will? So I just want to know what you think about that. And then secondly, have you thought about student codes of conduct? So not hate speech codes, but rather codes of conduct that university administrators might be able to use to to restrict certain behaviors based upon, say, a code of conduct that requires students to respect each other's viewpoints. So it's not, that could be used as the reason for restricting speech. And I just wondered if you might speak to those two things very quickly. Thank you.
I have a code of conduct like that in my syllabus, and I say, we need to take this seriously for exactly that reason. We're going to be respectful. We can disagree. We're going to be respectful because these are passionately held beliefs. And then I try to do some of the in-classroom pedagogy that I was talking about earlier, of getting them to talk to each other and also to use technology so that they can see where they are in the classroom. So I think codes of conduct where we say we're mutually engaged in in a learning endeavor and getting buy-in for that, right? Another thing we haven't talked about a lot here is sort of the procedural justice impact. If the students are involved in coming up with the code of conduct, they're going to be more invested in it, and they're going to be, so I think talking about it, getting them to commit to seeing themselves as part of that conversation. On your first point, the poster board, I think it's really interesting, right? Is it a poster that covers up every other poster? Is it critical of an administrator? Does it use, racial epithets? That one's complicated.
To your second question, the University of Chicago's policy statement on free speech does an excellent job, in my opinion, of not only setting forth the university's own ideals on freedom of expression, but stating that as a corollary to that, we expect campus community members in their own daily lives on campus to carry forth those ideals. So it's not just we as the University of Chicago protect free speech and academic freedom, but also we expect students and faculty and everyone else on campus to live those ideals and to have the proper respect for other people's ability to speak their minds. I think certainly there's room in academia for those kinds of codes and those norms to be codified into policy. On the poster issue, I agree with the idea that what I would say is if you have a designated bulletin board or whatever space for certain kinds of posters, if a university wants by practice to limit a certain space to announcements about campus events or about an academic department or units, goings on. I think that's different from a poster space that's kind of more of a free-for-all area. So I think with the first one, you can have more regulation to the designated content there. If you're talking about something that's just open for student postings, but then you take something down because it's controversial or offensive, then you're in a much murkier position.
Yeah, I agree with that. I think it's a designated kind of public forum to be technical. If it's for that particular purpose, and it's okay, especially if you have a lot of other domains. We haven't talked about free speech zones here, which have been litigated. Fire has done a great job talking about them. The more limited you have, you Hyde Park the speech. You put it over here. And I always consider that like quarantining the campus from free speech. So it's always a major problem. But otherwise, that kind of limited public forum or designated public forum would work. I don't like the term codes of conduct because code implies sanction. But a policy, I totally agree with both of you. And we actually have one at Wisconsin that I helped write that deals with sort of the importance of free speech. It takes all the free speech principles and academic freedom principles, but then also talks about the cultural context which will be conducive to the honest and civil exchange of ideas. And I think that's not only justified, but I think it's necessary, especially in today's environment. But I wouldn't call it a code. You can't punish a student for being uncivil. I mean, that opens the door to all sorts of slippery slope problems. And I think it's also wrong in principle, but you should educate along those lines. And indeed, that speaks to the academic freedom context of academic responsibility, which is really the most important thing about a university. I'm with Post on that, even though I also believe there should be a free speech area, because I think the two realms are dialectically related and enhance each other if they're done right.
Well, I think we should thank our panel for demonstrating some civil dialogue and then have lunch.
We have one panel left this afternoon. We have the pleasure of having an adjunct professor of law at Arizona State University, who is also the general counsel to the governor of Arizona, Mike Liberty, who's going to moderate a panel about state government, state legislatures wanting to intervene in public universities on these questions of free speech and intellectual diversity, and whether that stands in tension with principles of academic freedom. So we hope you will stick around for that, return. We'll start that as close as we can to on time at 1:15. We do have lunch for everybody here, right outside in the courtyard area, and then of course you're welcome to either sit outside or come inside to enjoy lunch. I do have one sort of substantive note, since Professor Baer brought up the question of equality. There had been a lot of discussion in our first 2 days and earlier today about liberty. So a reminder that we have a pocket constitution along with other materials out in the lobby, and following the model of the James Madison program at Princeton University, we have not only the Declaration of Independence and the Constitution, but also the Gettysburg Address, which rather prominently raises the question of equality in relation to liberty. So I'm not suggesting that you read the pocket constitution over lunch, but it's there for your enjoyment. So we will reconvene as close as we can to 1:15 for our final panel. Thank you.